name is Serene. I'm from P.E.A.C.E, and I'm so excited to have Nick Wright here today with us to do a webinar on getting your charity status, the pros and cons, as well as any questions anybody has. Over to Nick just to do a short introduction, if that's okay.
Hi, everyone. Thanks for joining the call. I'm excited to be here and talk to all of you. My name is Nick Wright, and I'm a corporate commercial lawyer. I've been practicing corporate commercial law for over 12 years now. And throughout that time, I've been actively involved in not-for-profit and charity work as well, which is the same sort of work as corporate commercial law, only in the not-for-profit space. I have a long background being involved in animal issues. I was the founder of Animal Justice, which is a national animal advocacy organization. I've sat on the board of a number of other animal organizations, including the Toronto Vegetarian Food Bank. And then over the years, I've assisted a number of animal-related charities apply successfully for charitable status. And in the last few years, I've also assisted a number of BC animal sanctuaries get their charitable status. So it's a kind of a niche area, charitable status for animal sanctuaries, that has some specific factors that need to be taken into account. And I'm happy to be here today to discuss those with you.
So excited. Thank you so much. So one of the first questions that we have is, can you please explain the process if someone is interested in getting their charity status?
Okay, so for either a new or existing animal sanctuary, there are a number of considerations. Some of them are to ensure that as an entity, you in fact qualify for charitable status. And that's the type of work you engage in, the type of programs you engage in. And then also the administrative component to communicate that compliance with the Canada Revenue Agency in a way that will result in being granted charitable status. All animal sanctuaries, if operating in a certain way, should be eligible, at least in theory, for charitable status. And from the CRA, we've been given sample purposes or objects that they'll find to be charitable. So I'll go over each of the different components to give a sense of what's involved. In terms of timeline, it can be a slow process depending on the amount of back and forth with the Canada Revenue Agency and their backlog. You can expect it to take between 10 or 12 months and possibly longer if there's back and forth communication and they're slow to respond each time. Traditionally, it takes them about a month to make any response. So if there's more back and forth, it takes longer. But generally, you can anticipate around 10 to 12 months from the time of application to being granted charitable status, assuming that the application is successful. So a first consideration to take into account is how you structured your organization. It would make sense in almost all circumstances, though it's not technically required, to incorporate. Now in BC, it would generally make sense to incorporate as a not-for-profit under the BC Societies Act. And the reason why you'd want to incorporate is that it protects the individuals involved against personal liability by separating personal responsibility by creating a separate legal entity, and also makes it easier to make changes to the organization if different people come and go. A partnership, a constitution-based organization, which is a quasi-partnership, or a sole proprietorship would be other business models. But really, there's no reason why you wouldn't incorporate, likely in BC under the BC Societies Act, to set up that not-for-profit to apply for charitable status. The amount of work involved in applying, it wouldn't make sense to use a different business entity unless there is some compelling reason, but normally not. So once you've incorporated as a not-for-profit, you want to ensure that your purposes are charitable. And this is something that's done at the time of application to become a society. There's particular language that in recent months I've been receiving from the Charities Directorate as to what will qualify. I can distribute that. So in order to be registered as a charity, your corporate purposes have to be charitable at common law. And that's interpreted by the CRA Charities Directorate. The purposes that I just sent have been found and will likely in future be found to be charitable at the time of application, and they apply to an animal sanctuary. So normally, unless there's a compelling reason to have the purposes be something different, it would make sense to use the purposes to ensure that the CRA will find them compliant. if you apply with different purposes, or if you have different purposes already, you're already set up your society, it doesn't make sense to change them prior to applying. What you do is apply for charitable status, and then the CRA will say, will assess whether they view your purposes to be charitable. And if not, they'll say, now you need to change your purposes in order to get registered. So that text will probably apply for most animal sanctuaries, and is what the CRA will likely find to be charitable. And just to summarize, for those who don't see the text, there's the purpose of promoting animal welfare by rescuing and providing care for stray, abandoned, abused, or surrendered animals, and operating an adoption program. One important factor is that in order to be charitable, there has to be a program to adopt the animals out unless the animal is unable to be adopted. And the purpose behind that is they don't want to be giving charitable status to organizations that are merely keeping animals. Rather, they should be serving the purpose of rehabilitating and adopting out animals when possible. Exceptions being animals that for various reasons cannot be adopted out. The other is to advance education by providing workshops, seminars, classes, and presentations. So educating the public, which is something that sanctuaries often do. And then the third is to be able to maintain funds and transfer funds to other charities under the Act. And that may be something that you want to do. So including it as an object makes sense, just in case you want that additional flexibility. So once you've incorporated as a society in British Columbia, and there are different pieces of legislation that may apply if you're not in BC, you want to make sure that you go to the BC Society's website and register for what's called a P.E.A.C.E account. Basically, it's the account for the corporation's British Columbia website that allows you to do filings, make changes, and receive information about your society. And that will be important because if we need to make any changes to the society once it's been created, that account will have to be in place in order for us to do so. Additionally, you then want to make sure that you set up a Canada Revenue Agency My Business account, and likewise, it's the online portal with the Canada Revenue Agency for the organization. This is now essential because they no longer accept paper applications. You have to apply online. So you set up the BC-EID account on the BC Society's webpage. You set up your Canada Revenue Agency My Business account online. And then additionally, if it's not showing when you sign up, you need to make sure that you have a CRA RR account, and that's the charitable account. If it's not on your CRA account when you sign up, then you can apply for it via the account, and that number that will then be assigned will allow you to apply for charitable status.
So that's sent to you, sorry, Nick, so that's sent to you after you've gone through the process of incorporating, correct?
Correct. So once you've incorporated, there's a process online to apply for your account for both services.
And what's like if you're not in BC, what is it called? It's not it's a society in BC, but what's the different provinces? Because we are doing this for all of Canada.
So when you incorporate in Canada, you can either incorporate federally or by province. For example, in Ontario, generally I suggest incorporating federally because there's no fee associated with registering in Ontario. And federally, there's the Canada Not-for-Profit Corporations Act, and there's equivalent provincial legislation. In other provinces, there's a fee associated with incorporating federally, so it often makes sense to incorporate in your respective province. Okay. But so generally, Ontario, you can incorporate provincially as a not-for-profit corporation. The federal system is better, but other provinces often have a fee and additional compliance required for federal corporations. So that's why in British Columbia, you're better off incorporating provincially because there's an annual fee associated. If you're an entity that has numerous operations in different provinces, then it may make sense to incorporate federally. But generally speaking, for anyone in BC, you want to incorporate under the Societies Act provincially.
Thank you.
And then once you've signed up for your CRA My Business account, then if you're working with someone such as myself who's assisting with the application, you need to grant them third-party access. And there's a link and form that you can click on and fill out in order to do so from the My Business account. So these steps, while administrative and somewhat dry, are required in order to apply and to make any required changes. And oftentimes these steps are what will hold up the application if there's confusion or delay or problems getting these accounts set up. So it's something you can do once incorporating. So I encourage everyone to go and do so, because they're important accounts to have in order to operate and administer your not-for-profit. Once all of that is set up and in place, then you can apply for charitable status via the CRA portal. And again, you need your RR account in order to do so. You can generate the required information from the CRA website. The Charities Directorate has a page that can generate a list of the different information that you need to provide them. Or if you're working with someone like myself who's assisting, they would likely provide that information as to what you need to provide. But generally speaking, it's the corporate information, such as the constating documents, the articles of incorporation, the address, the names of the directors and people involved, etc. You have to provide the financial statements of the organization if it's an ongoing operation, and a 12-month budget. If it's a new organization, then the forecast, the 12-month budget forecast would only be required. And then additionally, you have to provide a detailed description of your existing or anticipated activities that fall under the different charitable purposes. And when doing this, you need to provide a fair bit of detail to demonstrate either that you're carrying out the activities or that you have a detailed plan as to how you're going to carry them out. So for example, if you're educating the public, if you had lesson plans or educational materials, if you have details about where your operation is located, who's involved, who are the staff people or volunteers that carry out different programs, then all of that can be provided as supporting documentation in order to communicate to the officer appointed to review the application that either you're in fact engaged in these charitable activities or you have a plan to carry out the charitable activities moving forward. So once all of that has been submitted, oftentimes there's a lengthy wait, maybe 6 or 7 months until there's a response. And then there's some back and forth. Oftentimes they request additional information or they may have concerns about the purposes, require that the purposes be amended, likely if it's something other than what I provided to the group in the chat feature. A couple of points that are issues that often come up for animal rescues is as a charity, you're not permitted to provide a private benefit to individuals. So what that means, for example, is if you're operating the charity on private land, then any rent that's paid, any charitable money that's used to improve the property can't be at above the fair market rate. The idea being that the receipted funds need to be going towards the charitable purposes and not for the benefit of a private individual. So oftentimes what they'll want to see is a lease agreement and or other documentation that shows whenever there's the possibility of a private benefit that in fact there's an arrangement in place and that the private individuals aren't receiving a benefit beyond what the fair market value is. For example, renting the space. So a lease agreement or a document outlining what the arrangement is between the charity and the owners of the land is also something that is important, and including it in the first instance can expedite the application. So once all that's been submitted, then you wait a period of time, get a response. Oftentimes there's some back and forth providing additional information. And then normally the charity receives its charitable status. And at that point, you could then start issuing receipts. And you're also having to submit a charitable annual return, which is different than the not-for-profit annual return, and will need to ensure on an ongoing basis that you're engaged in charitable activities. Now, one significant change in recent years that's been implemented is that now charities are permitted to engage in political activity. nonpartisan political activity. For animal organizations, previously this was a significant issue because many organizations had a charitable component and also a nonpartisan political component where they're advocating for legislative or policy changes. So now with that change, an organization, so long as it isn't supporting a particular political party or candidate, can in fact engage in nonpartisan political activity.
Thank you. Awesome. Thank you so much. And so just to clarify, when you incorporate, it's kind of like incorporating as a nonprofit, registering as a nonprofit, because anybody can say they're a nonprofit, but till you actually incorporate, that's when you become accountable, right? That's when you have to create the bylaws and the board of directors and everything like that, correct?
Under the Income Tax Act, there's a definition of a not-for-profit. You can apply to be a not-for-profit with the CRA for an entity other than a corporation, as I understand it. But when you incorporate as a not-for-profit corporation, and when you do so in a manner that doesn't disqualify you from being a not-for-profit, for example, you can't have a profitable purpose. Your purpose can't be to make money, essentially. So long as you're compliant with those types of requirements, then you won't have an issue. So once you incorporate as a not-for-profit, then you'll be able to operate without having to pay taxes on any profits or any proceeds of the organization, which is separate from a for-profit because there are tax requirements for for-profit corporations, but also separate from a charity because unlike a charity, a not-for-profit can't issue tax receipts that are tax deductible.
So it's like the main difference you would say between a non-for-profit and like an incorporated non-for-profit and a charity, that the tax receipts. Is there any other differences other than the tax filings and things like that?
So a charity is generally a not-for-profit corporation that has purposes that are deemed to be charitable at common law, and that has been authorized by the Canada Revenue Agency to issue tax receipts for donations made to the charity. And the restrictions on its ongoing operations are primarily that it can't engage in partisan political activity and that it has to engage in primarily charitable purposes. There's some additional requirements that a charity has to meet as well, but for our purposes, we don't really need to go into them.
Okay, perfect. What are some, okay, so I guess that's kind of like, what are some of the pros of getting your charity and what are some of the cons?
Okay, so I'm also getting a question, can you discuss donation in kind? So pros and cons. The pro is that you can issue tax receipts. Now, generally people donating under $100 don't care whether or not they get a tax receipt. So for some organizations that don't receive large donations, it may not be important to get charitable status. It may not be worth the extra effort and compliance. But for those who want to apply to charitable foundation to apply for grants, or for those who hope to receive donations in larger amounts where people may want to receive a tax receipt, then it may be worth the time and effort to apply for charitable status. But the main benefit would be the ability to apply for large grants from charitable foundations, which can only give grants to registered charities or qualified donees, and the ability to offer that as an incentive for large donors. When you make a donation to a charity, the rule, there's different ways you could characterize a donation. One is a straight cash donation, one is a donation in kind, and then the other is a donation that could be in kind or cash with a benefit. Generally the rule is that if you receive the benefit as the donor, the monetary value of that benefit has to be deducted from the donation. For example, if as a fundraiser you hold a lavish gala with a meal and you sell tickets, you can give charitable receipts for the ticket, but it has to be minus the cost of the meal. So let's say the ticket's $100, but the meal is $50. You can only issue a receipt for $50. And that applies for any benefit, no matter what its character. So in terms of your donation receipt precedents or templates, you'd often have a a donation receipt for a straight cash donation, so just a receipt for the funds made, or where there's an amount subtracted for a benefit received. For in-kind donations, the rule is that the receipt is for the fair market value of the donation. And there can be complexity around determining what that fair market value is, in which case, for larger amounts, you may want to get some sort of formal assessment, or if it's a smaller amount, then most likely you just do your give a best efforts attempt to give the fair market value. Probably if it's a non-arm's length donation, you'd want to be particularly careful to show that a process had been gone through to ensure that the fair market value is in fact correct, and that there's not a false or inaccurate value being used in order to issue receipts.
So for the gift in kind, what about charities that give out like calendars or magnets, like Christmas time, people send things to their donors too. Does that count?
Well, I guess theoretically it would, but if it's not material, then practically it wouldn't be included. Like the costs of a brochure or mailing would be an expense rather than a gift. Probably gifts that are sent out like magnets would be considered to be immaterial. But if it's something more substantive that has a monetary or fair market value, then you may need to think about whether or not that would apply.
Okay. And who you would probably just call the CRA to confirm, or what would you do?
You could call the CRA, but you won't necessarily get a correct answer from someone at the CRA. It would be a bit of just who you happen to get on the phone. So you can either go to the CRA website and inform yourself, or you could seek assistance from a lawyer to advise. And again, it depends on the amount at issue. Like if it's something that is immaterial, then it's less likely to be of concern.
Okay.
But if there's more money at issue, then the CRA is more likely to take issue with it.
Okay, perfect. We do have a question. If the purpose of the sanctuary is not to rehome rescues, do you have to prove adoption in any way?
So at the time of application, it depends on whether you're an existing operation or new operation. If you're an existing operation, then you need to provide information about the programs you're engaged in and or programs you expect to be engaged in which case you'd have to show that you have a process in place for the adoption, and there's no requirement as to what that supporting documentation is generally, but the more detailed the better, and the more evidence and particulars you can provide, the more likely you are to persuade the officer reviewing the application. If it's a anticipated program or a new organization that's yet to actually undertake the activities, then you're just talking about what your plan is. And you want to show enough detail that you've carefully thought out your plan and you have a specific idea about how that will look and how it will operate. But once you've received charitable status, there's no further review and there's no prohibition from changing your plan. So it's important for an anticipated program or a new organization that you have that plan, but there won't be additional audits or reviews post application. Now, a caveat to that would be there may be an audit. It's unlikely, but they do charitable audits, especially if an issue arises or there's a complaint or something comes up in the media, in which case they could audit to ensure that the charity is compliant with the charitable purposes. But so long as you're compliant with the charitable purposes, the fact that you've not decided to move forward with a proposed activity wouldn't invalidate your registration.
Could something like partnering with P.E.A.C.E as a foster location for rescues and future placement at other sanctuaries qualify for this in any way? Like working with another organization who rescues and like you temporary foster or help with quarantining.
Okay, so if I understand the question more specifically, is the idea what do sanctuaries do where they don't intend to
Rehome. But they do
find new
take in
homes.
animals, let's say they work
Yeah.
with us, they take in animals because we don't have a physical location yet.
Mhm.
And they take in animals and they temporary home them, look after them for us because they work with us to home them. So it's kind of like working through this adoption program.
So what I would suggest for the purposes of applying for charitable status is to have a plan in place to rehome and adopt out animals and a policy in place so that you can show that if you end up with an animal that can be rehomed, that you have a plan in place and you have policies and procedures in place to do so. Because that's one thing they'll be looking for and that they're sensitive to. They don't want to be giving charitable status to essentially a hobby farm or someone's private farm where they just keep animals. They want to ensure that it's serving this charitable purpose of rehabilitating and or rehoming animals. Now, there are exceptions to that where if the animal can't be rehomed, it's compliant with the charitable purposes to keep the animal indefinitely. But for the purposes of applying for charitable status, you'd want to show that you're open to rehoming animals and then you have a plan in place and all the policies in place in order to do so. And maybe it would end up that for whatever reason, you don't receive animals that are suitable for rehoming. But in all likelihood, in order to get charitable status, you'd need to show that you have that plan in place.
So I think one of the questions was regarding like the structure of setting up your charity with like regards to members, board of directors, committees, and then volunteers.
So a good way to think about not-for-profits and charities, like an incorporated charity is also a not-for-profit because they're incorporated under the relevant not-for-profit legislation, is analogous to a for-profit private corporation, which is something generally I think people are more familiar with. So for-profit private corporations, the shareholders are the people who often put up the money, and they're the owners of the organization, and ultimately they control it. So analogously, there are members of a not-for-profit corporation who are like the shareholders. And then they delegate their authority to operate and control the corporation to the board of directors. And the board of directors, their duty is to oversee the corporation's operations from a higher level perspective. Often, perhaps they'd have a monthly board meeting where they would get a report about what's going on. They'd implement policies. Perhaps they'd be involved with hiring or firing an executive director or senior officer positions. And they wouldn't be, at least from a conceptual perspective, often they wouldn't be engaged in the day-to-day operations. And then they would in turn delegate their responsibility to oversee the management of the corporation to the senior officers, like the executive director or CEO, the treasurer, or CFO, who would be responsible for managing the day-to-day operations. And then those people might hire staff who would operate under their supervision. And then that kind of staff could instead be volunteers in the situation of a not-for-profit or charity. So while that makes sense if it's a very large organization, that there'd be different people who are the members or shareholders, the board of directors, the senior officers, and then the staff or volunteers. Oftentimes for small, closely held corporations, it's all the same people. So it could conceivably be one person who's the sole shareholder, the sole director, the sole officer, if they so decide to appoint themselves as an officer, and then whatever other roles the organization might have, or it could be a handful of people. So there are requirements around the number of directors that are appointed. And it differs a bit by province as well. But for example, under the Canada Not-for-Profit Corporations Act, if you pass a certain threshold and are receiving donations from the public, you have to have a minimum of 3 directors. So it can depend based on what your activities are, the number of people involved. But generally, you'd have that breakdown. And then to go to control the corporation, if you think of it as a shareholder, the members are the people who control the corporation, the organization. And there are a few different ways that not-for-profits often structure their membership to delegate or distribute that ultimate control of the corporation. One way is to have a very large number of members. Sometimes there might be a $10 membership fee, for example, and anyone who's interested and supports the organization's objects can join. This can be effective for organizations that have a broad community purpose, that want to engage a large group of stakeholders, and that want to really involve the community in whatever the activity is. The downside is that it creates a lot of politics, administrative burden. You have to have annual general meetings that are often large events that a lot of people attend. So another way to do it that's fairly common is to make the board of directors also the members, in which case control would be held amongst a small group of people. And that can be a better way to do it when it's a small group of people that are controlling and carrying out the activities of the organization. Or if it's in effect one person or a small group of people's organization and they want to retain control, they can set up the bylaws where they would appoint themselves as the members, and then they could go and appoint officers to oversee the management of the corporation from a broad level, and could also ensure the compliance with any requirements to have a minimum of 3 directors or any other director requirements that may exist under statute. So broadly speaking, it depends on how you want to set it up and what makes sense from your perspective. If it's to be controlled by 1 or 2 or a small group of individuals, they could be the sole members and they appoint the board, and the board wouldn't have the ability to alter the membership, so they control the organization. It could be the board that controls it, where the membership and the board are the same, and then there'd be a process for bringing on new board members who could then also be members. Or for a larger organization with broad-based community purpose, you may have many, many members who sign up paying a fee, in which case you involve more stakeholders. Perhaps it's more effective in engaging communities, but then there's more work involved in having the AGMs consulting the community. Ultimately, it's pretty broad the way you can structure it. You can structure things more or less however you want, but that would be determined by the bylaws. And you may have to do some custom drafting in preparing your bylaws to ensure that the process for appointing members is as desired.
Yeah, and then there's also like the difference between voting members and non-voting members too, correct? Like, does voting members have more say in your operations?
Yep, you can have, when doing your bylaws, you can have any membership structure that you like. Voting, non-voting, you could have people who have extra votes or fewer votes. So really, it's up to you how you want to structure it. It's pretty broad what you can do, but you just need to think about your particular circumstance, who's involved, who you want to have ultimate control of the entity of the corporation, who you want to be involved in the general oversight and the day-to-day operations. You can give some thought to that and come up with something that makes sense, and where control and responsibility is commensurate to people's duty or obligation or contribution.
And the big thing is too, like, let's say you start off, like you're a brand new sanctuary. You can start with having one membership model. And then as you grow and you want to open that membership, you just have to go and change your bylaws, correct?
Yeah, and generally changing the bylaws requires 2/3 majority vote of the members.
Okay, so it can always be changed.
Yep.
Was that the Canadian NFP Act? Somebody's asking.
Yeah, the Canadian Not-for-Profit Corporations Act is the federal legislation for incorporating not-for-profits. And then each province has analogous legislation, because under the Constitution Act of 1867, the responsibility for different areas were delegated either federally or provincially. And it's been interpreted that the creation of a corporation is dual federal and provincial jurisdiction. So every jurisdiction in Canada has legislation that allows you to incorporate. generally speaking, the differences are pretty minor. And broadly speaking, you probably say it doesn't matter a whole lot, but it can matter, for example, for your annual fees or the ease with which you administer the corporation. But like I said, in BC, for an animal sanctuary, you'd likely want to create a society under the Societies Act. In Ontario, you can incorporate provincially as a not-for-profit, but generally I suggest incorporating federally as a not-for-profit because their system is much easier to use and much more efficient, whereas provincially in Ontario can be a headache dealing with the provincial government.
Okay, perfect. Somebody asked, in BC, do we need to maintain our society status once we have charitable status?
Yes, so you still have a society, you still have the not-for-profit. There's an annual filing that you have to do. You can do all that via the B.C.E.ID account that hopefully you created at the time of setting up the society.
Perfect. Okay, okay, you did that. I think you did explain the things a charity can give tax receipts for and things they can't. There was kind of you kind of went over that, but is there anything that people sometimes get wrong that they can't give tax receipts for?
I would think about it slightly differently. Rather than what you can and can't give tax receipts for, it's more about what the charity can and can't do. So anyone who gives money to a charity, save for people who received a benefit, like I mentioned earlier, can receive a tax receipt for that donation. However, the charity is restricted in the activities that it engages in and the way that it spends its money. So for example, a charity, generally speaking, has to engage primarily in its charitable objects. There are some exceptions. For example, if you operate a gift shop, operating a shop isn't charitable, but it's considered ancillary to the main charitable purpose of the organization. So long as the charity is engaged in carrying out its charitable activities, then it's compliant. And then from the perspective of the donor, unless they're receiving a benefit, then they're entitled to a tax receipt. And if they're paying taxes in Canada, they can then use that to reduce their taxable income.
Perfectly said, thank you. And what are some of the most common mistakes a new charity makes?
Well, probably a lot of the issues are just practical administration issues. Like in my experience, sometimes people who operate animal sanctuaries have difficulty with things like setting up the different accounts, dealing with CRA, which can always be frustrating, and getting the administrative elements both set up in order to allow for the application for charitable status, but then also providing the necessary supporting documentation and budget. For example, the financial statements and 12-month budget, detailed descriptions about the activities, and then supporting documents that will demonstrate either the existing operations or intended operations. In the past, it was an issue because oftentimes sanctuaries would have materials that would be advocacy materials or interpreted as advocacy materials by the CRA. So that was always a sensitivity because previously a political activity was prohibited for charities. That's less of an issue now because that's been overturned by the courts and then the legislature. So there can be an advocacy component. But even so, the main charitable purposes should be what's highlighted and communicated in all materials. So yeah, in my experience assisting with organizations applying for charitable status, the challenge has been getting those accounts set up and then providing the financials and supporting materials in a form that the CRA will accept.
So like more the administrative, you need like somebody a volunteer to help you with that in a sense.
Yeah, and like ideally you'd have an accountant and the accountant would have done previous financial statements, possibly audited financial statements, and then they'd also be able to assist with a budget for the next 12 months.
Yeah, that's good. Thank you. Yeah, I think that was all the questions we had here. Because the other question, which we didn't know, which we'll just touch base on, is there any programs you recommend for creating tax receipts for donees? we know that through, as soon as you create you get your Canada status, charity status, sorry, that Canada Helps, which is also a charity, they set up an account for you, which you can receive donations through, and they automatically create tax receipts for people, as well as PayPal giving account. So there's lots of options. And I know there is, if you Google it, there's a whole bunch of software options for people. I know because we're a smaller charity, you can just create like yourself, like physically create receipts for people. And there are resources online and samples on what the different receipts needs to look like. Oh, we've got another question. Selling merchandise. Do we need permission from the CRA to do this?
No, like I mentioned before, you can be engaged in non-charitable activities that are ancillary to the main purposes. Selling merchandise in order to raise funds would qualify under that. So as long as your main activity isn't selling the merchandise, then that's fine.
Yeah, and you're not giving a tax receipt for the amount given
as long
for the product.
as you're a charity that sells merchandise, not a merchandise business that has a side charity.
Yeah.
In fact, it's fine, broadly speaking.
Yeah, because lots of charities have the thrift stores, right? Attached to them to help with funding. But thank you, Nick. It's been very educational, even for me, because I know Hugo is the main contact with you, doing all these things. So I really appreciate you coming on today, and teaching us and just answering all our questions.
Yeah, happy to be here and hope that it's been of some assistance. And I suggest that a main takeaway is if you're setting up a society and the objects that I sent in the chat seem consistent with your plan, to use those objects if you plan to apply as a charity. Yeah, so my website is wrightbusinesslaw.ca. That's WRIGHT businesslaw.ca. And you can send me an email at info@wrightbusinesslaw.ca. There's also a contact page where you can schedule a telephone call on the website.
Awesome. Thank you. And good luck with the rest of your day.
Okay, thanks so much.
Thank you, everybody. Take care.
Have a good one.